They don't get to run another candidate, but they will run a campaign to say, we believe that Joe Blow should be removed from the Supreme Court. Please vote no, he should not be retained. This is a scary thing. On a single issue, we can get a judge removed from office. On a single political issue, we can get a judge removed from office. And of course, they think then they'll get to prevail upon the governor and we'll get him to appoint somebody we like. Well, I may get somebody even worse. But it's an attempt to make judges react to politics. And the whole idea of judges is they're not supposed to be reacting to politics. They're supposed to be immune from this. They're supposed to be deciding what's the law and applying what the law is and what the Constitution says, not just what most of the people want. But this is a most of the people issue, they try to make it look like, and they have tried unsuccessfully to have judges removed from the Supreme Court 2 years ago and 4 years ago, because they're on rotating terms. When you have these 6-year terms, well, we're going to see in a minute, there are a lot of judges on the court, and they're on 6-year terms and they rotate. So we don't have, theoretically, everybody getting thrown out at one time and 9 new ones coming in.
6 years trial and appellate?
Trial and appellate judges also are on rotating terms.
All 6-year terms?
Alternating terms is what I'm trying to say.
6-year terms.
Every 2 years, you'll elect a bunch of judges. So that we'll have theoretically 1/3 new judges. 2 years later, maybe another third. Not going to be. Judges get reelected. Not always, but people have heard of the incumbent judge. They haven't heard of the new guy. Maybe. Maybe he used to be a mayor somewhere, and maybe they have heard of it, you know, but by a large part, once you're on in the state court system. But you do stand for re-election every 6 years, or you stand for merit retention every 6 years. Do you get to stay, or do you get removed? Okay. We talked about the trial court, going to decide what the facts are and apply the law. And the state intermediate court and the state appellate court are only going to look at the law and not the facts. And now, I want to talk real specifically about Florida courts. I'm going to ask you all to pass these around if you would. This is a chart of the setup of the Florida courts. This is what this. Yes, sir.
Is the Supreme Court, is it still, you're just going in front of one judge, or is it like a couple of judges there?
No. They get bigger as you go up. We'll talk about that in a minute. They get larger panels, larger number of judges on the court, and larger number of judges hearing a case. Very rarely is an appellate court heard by one judge. Is an appellate case heard by one judge. The whole concept is, let's get 3 or 5 or 7 or 9 learned guys together and let them decide what's best and let them write a scholarly opinion. It'll be the law for everybody to follow in the future. Okay, our Florida chart here. Starting at the bottom. Well, let me say one more thing. The types of courts are obviously up and down the middle. The types of cases that they hear are on the sides. On the left side, that column should be entitled Mandatory Jurisdiction. Starting right above constitutional questions in blue on the left column, that's mandatory jurisdiction. This is cases that the appellate court or the court must hear. The things on the right are what we call discretionary jurisdiction. They get to the appellate courts get to decide whether or not they want to hear it. And as we're going to talk about as you go up the ladder, more and more often they get to say, no, we're not going to hear that. No. No appeal, no opinion, no ruling. Whatever the lower court did, that's the end of it. We're not even taking the case. But that doesn't apply, obviously, at the trial court level. Now, trial courts we talked about. First type of trial courts are trial courts. That's the yellow and green. In Florida, we got 2 types of trial courts. County courts and circuit courts. Now, We used to have a lower notch, just be aware of this. We used to have municipal courts. Cities had courts. Fort Lauderdale in the 70s had a municipal court, conveniently in the police station, where the police station is right now. And what it did was traffic tickets. And you got a traffic ticket, you went to municipal court in front of a municipal judge, and he made a ruling. In 1977, the legislature said no more. Abolished municipal courts for every city, whether you like it or not, you may not have one. And decided that every Florida case is going to be heard by a Florida court. So you start at the bottom with the county courts. This is one of the two types of trial courts in Florida. There are 67 counties in Florida. There are 67 county courts. Everybody's got one. Every county has one. Now, it doesn't mean there's just one county courthouse, though. In Broward County, I know of 3, and I bet you there's more. You know, the courthouse, the county courthouse right here, yeah, there's a county court in there, but there's a west courthouse out somewhere off 595 somewhere.
Pine Island.
There's a, pardon me?
Pine Island and
Pine Island is it? Okay, I knew it was Pine Island or University or something. There's a north courthouse in Pompano somewhere. These are called satellite courthouses, and the county court sometimes meets there. Now, here's what the county court does. The stuff on the left in green. Criminal misdemeanors. Not the focus of our stuff, but let me tell you what a misdemeanor and a felony is. Misdemeanor is a little crime, felony is a big crime. Misdemeanor is anything punishable by, you don't have to know this, anything punishable by 1 year or less in prison. That's a misdemeanor. A felony is punishable by 1 year or more in prison. If it's a crime that is punishable by 1 year or less, it's a misdemeanor, it's tried by the county court. Let's skip to the bottom of that for a minute, and that of course includes traffic. Traffic crimes, technically, although they're called civil infractions or something, are also tried in the county court. Civil matters, though, are tried also in the county court. And there are 2 groups of civil type cases. And they turn on basically how much money is involved. The small claims that you see, that's all civil cases up to $5,000 in controversy. How much are you suing this guy for? You're suing him for $4,000, this is your court. You're suing him for $20,000, this is not your court. Now, this is what you see on TV. This is the people's court. This is no lawyers. This is one judge. This is usually not witnesses. Both sides get up and say, he stole my dog. Nah, he didn't. And, you know, and then the judge issues a ruling and decides what to do about it. They function under really streamlined procedures. They're called summary rules. Don't need to know that. I'll tell you, let me give you the other ones and then we'll come back to summary rules. If you have a bigger case, up to $15,000 civil case, well, you're also in county court, but you're in the civil division of the county court. There's a small claims division and the civil division. Now, the civil division plays just like the big boys in the circuit court. The civil division is lawyers. It's the Florida Rules of Civil Procedure. It's the type of stuff that you're used to seeing in a lawsuit, where the lawyer files a complaint, sheriff serves it with a summons on the defendant, says you got 30 days to answer, and the defendant answers, and then you have hearings and motions and discovery and all this stuff. That's the regular Florida civil rules. That's how trials function in Florida. That's what applies in the county court from $5,000 to $15,000. But in small claims court, it's real different. You go in to the clerk, and the clerk hands you a form, and you handwrite a complaint. This guy stole my dog. Dog was worth $3,000. The sheriff then serves that complaint, that handwritten complaint on the guy who's being sued, the defendant, but serves it with a special kind of summons. A small claims court summary procedure summons. And what that means is, it says, you're being sued. Attached is what you're being sued for. You will show up in court on this date at this time, and the judge will decide your case. Period. That's it. No depositions and discovery, and you get to file an answer, but you're both going to show up at that time, and the judge is going to hear both sides, and the judge is going to issue a ruling right then. No, you didn't steal your dog. And that's it. It's over. And that's the summary procedure. But otherwise, in county court, you're following the civil rules, which can take 2 years, 3 years, 5 years, however long the lawyers drag it out. That's what goes on in county court. That's a trial court. The main trial court in Florida is called the circuit court. That's yellow. There are 20 circuits in Florida. I'm sorry, yes, sir.
You have jurors on the county court?
No, you do not have jurors.
Civil? No? Okay.
You do not have jury. Judge only. Judge is going to decide everything. But you do have juries in circuit court. Circuit court is your primary trial court in Florida. There are 20 circuits. Don't need to know that. 17th is Broward, 11th is Dade, 15th is Palm Beach. Smaller counties, there may be 6 of them in a circuit. Because we got 20 circuits, but we've got 67 counties, so obviously we got to bunch some together in the boonies. There is a one-judge panel here, just like there was in the county court, but there may be a jury. But there's only going to be one judge. Now, ultimately the judge is going to make a ruling, after the jury maybe. But the important thing to know here is, normally the ruling of the judge is not published. He's not writing an opinion, or he may write one, but it's not getting published, it's not getting circulated, unless it's picked up by the press. The cases I alluded to earlier are 3 circuit judges ruling on the gay marriage issue, and they're writing 20, 30 pages of opinion. These guys want their rationale known, and they publicize it, and their opinions are lengthy and they're written up. But normally, circuit courts don't write opinions. They just say, you win. They make finding of fact. They decide, what are the facts? Did you or didn't you steal this guy's $20,000 dog? And I'm going to apply the law. Is it theft or isn't it? And make a ruling. Here's the types of cases they handle, in yellow on the left. Criminal matters or felonies, of course, the big ones. They handle, skipping to the third, civil cases over $15,000. Up to the moon. No upper limit, just a lower limit. Anything over $15,000 goes to the circuit court. In addition, there are a few other things they do, and it has nothing to do with the amount in controversy. They handle all family law matters, adoption, change of name, including juvenile matters. They handle all probate. Probate, somebody dies, what are we going to do with this estate? How are we going to pay the creditors? How are we going to distribute the assets? You know, read his will, etc. All probate, even $5,000 probate cases. Probate has to take place there. Theoretically, they handle appeals from the county court. Certainly in small claims court, you're not going to appeal. And it's discretionary, and the circuit court can say, nah. Theoretically, in a $14,000 civil case that had some importance that took place in the county court, they could appeal it to the circuit court, but that's pretty rare. One important thing that's not listed in the left of jurisdiction that affects you in the real estate business. The Florida statutes setting up the jurisdiction of the court say all actions to determine title and boundaries to real estate. All actions determining title and boundaries to real estate. Just about everything that you might litigate in real estate affects title. And it may affect boundaries. And what that means is all mortgage foreclosures are in the circuit court. All real estate disputes of any type, all real estate tax disputes, I got turned down for zoning, so I'm suing the city, suing the county, appealing a real estate ruling of an administrative agency. It all starts in the circuit court. All right, that's trial courts. We are finished with trial courts. In Florida, the county and circuit courts together comprise your trial court. Decides the facts, applies the law. Now, if you want to appeal what happened in the circuit court, you have the right, one time, the right to appeal to the district court. It's called the District Court of Appeal. That is our intermediate appellate court in Florida. Every state has it, different names, but there's always an intermediate appellate court. In Florida, they serve as a 3-judge panel when they hear your case. There are, I think, maybe a dozen. Well, let me back up. There are 5 courts of appeal in Florida, 5 district courts of appeal. Miami's the 3rd district. Broward and Palm Beach are in the 4th district. Our district court of appeals in West Palm Beach for Broward County. There are, I think, probably at least a dozen judges that serve on the 4th district court of appeal in West Palm Beach. But 3 of them will hear your case at any one time. And you will get a ruling from those 3 judges, and they will publish an opinion, and that opinion is precedent that we talked about earlier. And what that means is that the circuit courts and the county courts in Broward and Palm Beach County have to follow the law as determined by the 4th District Court of Appeal. That's precedent. Now, here's what they handle. On the left, they handle all matters that are not directly appealable to the Supreme Court of Florida, and those are very few that go straight up to the Supreme Court. And then they handle appeals of final actions of state agencies, like we talked about. Perhaps for certain types of state agencies, you go directly to the courts of appeal to argue against a ruling. There are no witnesses. There is no testimony. There is no jury. There is no finding of facts. Strictly, was the law applied correctly by the court below? Yes or no? These are the buzzwords, do we affirm what the court below did? Or do we reverse what the court below did? That's the bottom line. And then here's why. And here's why as a holding. Because we, the learned judges, think that it takes 2 out of 3 of them to make a decision. Those 2 out of 3, or all 3, write an opinion. If the judge doesn't like what the other 2, the majority did, he can write a dissenting opinion. We hear about those all the time at the Supreme Court.
Does he have to?
My own opinion, I think, is wrong, and here's why.
Does he have to?
I'm sorry?
Does he have to?
No, not at all. Can just vote no if he wants to, but if he wants to go on record and have everybody know what he thinks the law is for next time they come up, then he can write a dissenting opinion. Now, They don't have to write an opinion, though. They have to make a ruling. But they can just say, if all three of them agree that the court below acted correctly, they do something called, I need to know this, per curiam affirmed. That means we all agree they did it right. You're done. Your appeal is over. Now realize what's going on here. We had a trial in a trial court, and somebody didn't like it. So one of the two parties in the trial court, the one that lost, decides, I want to appeal. So he takes that same case and files an appeal with the court and says, I think the trial judge did the following thing wrong, or the following things, usually things, and I think the result should be different, and here's why. Lawyers write briefs, long books. Here's all the law, why we think the guy was wrong, and here's what we think the law ought to be, and here's why we think you ought to either agree or disagree with what the trial court did. The courts may or may not have oral argument, but the oral argument's only the lawyers. No more witnesses, no more testimony. Parties can come if they want to. Hell, you and I can come and sit and watch if we want to, but we're not gonna reinvent the wheel on the facts. The determination by the trial court on facts may not be disturbed. They can only say whether or not he applied the law correctly or incorrectly. And I'm dwelling on that, but that's the story all the way up through the system. That's always what's going on here in the appellate courts. No retrying of the facts, just a determination of whether or not the law was correctly applied in the court below. Yes, sir.
If you sue the state.
I'm sorry?
If you sue the state, do you do that directly at the Supreme Court?
No. You start at the trial court.
Okay, so
you start at the trial court. There's something, I'm not real good on this thing on the left side of the district courts of appeal, that's final actions of state agencies. There's something there about they're required to hear appeals of final actions of a state agency, but I'm not quite good on that. But no, if you sue the state, you sue the federal government, you start in the federal trial court. You sue the state, you start in the state trial court.
Okay.
If you're suing the state for $3,000, you start in the summary claims division, maybe, but you start in one of the trial courts and work your way up. Okay, for all intents and purposes, in Florida, this is your last appeal, you're done. When the District Court of Appeal has ruled on your case, if you don't like the result, well, that's probably too bad. You can ask that it be heard by the Supreme Court. They'll say no. Hell, you can ask for the U.S. Supreme Court to hear it if you want to, but they're going to say no too, unless they think there's some really pressing thing going on here. This is in all states, in the federal system too. We'll talk about the companion in a moment, but in much less detail. The intermediate appellate court is it. That's your appeal, and you're done. Now, maybe you've got a basis to go up to the state Supreme Court. There's one state Supreme Court, obviously, it's in Tallahassee. There are 7 justices on the state Supreme Court. 5 of them have to hear a case. 4 of them have to make a ruling, 4 of them have to agree to make a decision, 4 out of 5. That's a higher standard than most courts. Usually it's a simple majority. Florida law says 4 out of 5 judges Supreme Court judges have to agree to, of what the opinion's going to be. They're going to put all the same stuff we said. Briefs, lawyers' arguments, no testimony, no witnesses, no juries, no nothing. What's the law? Our lawyers are going to appear and have oral argument, and maybe the parties can come watch if they want to, but that's it. On the left is what they do. We talked first about criminal in each matter. Capital cases. Any case where the death penalty has been imposed by a lower court goes directly to the Supreme Court. Has to. You may not execute a prisoner in Florida without the Supreme Court saying so. And maybe the U.S. Supreme Court, we'll see. Or they'll see. But all capital cases have to be passed upon by the Florida Supreme Court before there can be an execution. That is an automatic appeal, and that goes directly, and I think that's this left side yellow arrow going from circuit court up to Supreme Court. I'm thinking that's the one it means. Others, constitutional questions under the Florida Constitution. And then these limited things, validating bonds and public utility cases. You know, we have a Florida Public Service Commission, and its cases all get heard there. On the right side is the discretionary things. These are the things the court might decide to hear if it wants to. The most important one is the bottom one. Certified questions that you see twice in the green at the bottom and in the bottom of the blue. Lower courts can say, we think we've got a real important issue here, and there's a lot of disagreement on what it is, and we certify the following question to the Supreme Court. Normally, the Supreme Court will accept those cases. They don't have to, but normally they will. The biggest thing is, as you recall, we've got 5 district courts in Florida making opinions and creating law. Sometimes they disagree. And sometimes the district court will say, hey, we think the law is ABC, and we see the other district courts think it's XYZ. We certify this question to the Supreme Court. Would you please decide this so that we have uniformity throughout the state? That's an important one. And hopefully they accept those cases, but sometimes not. Other stuff, is a statute valid or not? Sure, that's a biggie. But even the validity of statutes, that starts in the trial court. You want to sue the state of Florida because you think this statute violates the Constitution, you start in the trial court and you work your way up. But they're going to hear it. If particularly, they're going to hear it if a lower court has ruled a statute unconstitutional and void. Well, that's going up. Because obviously the legislature is not going to stand for having some judge declare that their statute unconstitutional. They want it heard by the Supreme Court. And they may not stand for it after that either. They may come back next year and say, okay, well, this is what it is. But that's a biggie. Construction of the Constitution or the U.S. Constitution, decisions affecting a class of constitutional officers, I don't know. That's Florida courts. Top 2, Supreme Court, District Court of Appeal, that's precedent. They're publishing opinions, that's precedent. That's what we talked about earlier, lower courts have to follow. All the district courts of appeal have to follow what the Supreme Court says the law is. Circuit courts, county courts have to follow the law of the Supreme Court and the district court and the district they're in. And the purpose of all that is to try to create some predictability. Let's try to give some people an idea what the law is, number one. But number 2, try to create predictability for lawyers and litigants when they go into court to have some idea what's going to happen here. Well, here's what the courts did before. But our facts are a little different. But that's the idea. And that's one of the areas of law that we talked about, precedent, court-made law, and here's where it comes from, and here's how, particularly where it comes from in Florida. Now, that's Florida courts. Federal courts, pretty similar. Names are a little different, a little confusing, but you've got U.S. district courts, you've got intermediate appellate courts, and you've got Supreme Court. We'll talk about those specifically in a second in much less detail. Does anybody know how you become a federal court judge?
Appointed by the president?
I'm sorry.
Appointed by the president?
Absolutely. Even your lowly, and I'd be shot for saying the word lowly, federal district court judge, trial court judge in the federal system is appointed by the president. And, Mark, right?
Yes.
What else?
I think it has to be Congress has to approve?
Perfect, confirmed by Congress. You don't hear about them. You hear about U.S. Supreme Court justices when they're being affirmed by Congress. Boy, they make a big damn deal out of that, you know, hearings and. But they have the same stuff going on for every federal trial court judge. Obviously, it's a political plum. The party that's in power and the president gets to appoint the judges. Congress, if they're fighting with the president, well, they get to not confirm it. Give me somebody else. How long do they serve? Anybody know?
Lifetime.
That's it. You're exactly right. They serve for life. That's huge. Once you're appointed, you serve until you die. There's not even any mandatory, you're 80, you have to retire. You die or you quit. Or, how do you get them out of office?
Impeachment almost.
Absolutely. Impeach them. Just like you try to impeach a president or get anybody out of office. You have to impeach a federal judge that had them removed. So once you're in, you're in. Many people don't know this, but we have a local political official who was a federal court judge and who was impeached. Congress had a trial and impeached him and threw him out as a federal judge. But everybody knew his name by then. So he got elected to the state legislature. And he's still there. And his name is very famous from his prior history as an impeached federal judge. So.
What is that name?
I'm sorry?
What is that name?
I'm not going to go there.
Well, I do have a quick question before you
Yeah.
move forward. The certified questions that typically go to the Supreme
Did you say
Court.
the certified question?
Yeah.
Well,
Now, it's also a discretionary jurisdiction of county courts. So what type of certified questions go to them?
I guess they could certify a question up to.
So you got it in green at the bottom on the right-hand side as well.
If they said, we think this is a question of great importance.
So I can throw a question to the trial
Oh,
court?
no, wait a minute, hold on.
The judge.
No. You don't decide that.
Okay.
The judge decides whether it's a certified question or not. Those cases are sent up by the judge of the lower level.
But we're at the county courts now, so we're at the lowest level. So who presents certified questions to them?
The judges did.
Or
Oh,
the
to
judges?
them? Oh, they don't hear any certified questions. I'm
So
sorry.
the judges
This makes it
confer
look
with
like
each
they're
other.
hearing a certified question?
No, what I'm saying is right down here.
Yeah, I understand what you're saying, but are you suggesting the chart makes it look like they hear certified questions?
Yeah, that's what I was
No,
thinking.
That's not what that
They
means.
just present.
It means theoretically they can certify a question up on appeal.
Oh, okay. I got you.
Yeah, the types of cases they hear are on the left. This certified questions is the judge decides, I'd like to send this up. And you're right, they can certify questions, but they sure can't hear any certified questions.
Okay.
Okay, yes, sir.
Are all these federal that located in Washington, D.C.? Most of these all take place?
On these federal courts, did you say?
Federal.
No, we're gonna talk about that right now. All right. But similar to the Florida courts. I want to reinforce this. 3 levels. Trial court, intermediate appellate court, Supreme Court. Same thing. Same types of things. Trial court, hears the witnesses and makes a decision. Intermediate appellate court, Supreme Court. All right. The trial courts in the federal court system are called the United States District Court. It's right next door. The U.S. District Court is at the intersection of Broward Boulevard and 3rd Avenue.
Yeah.
It's supposed to have kind of a waterfall down the front, but it's not watering it very often.
Is that what that's supposed to be?
Yeah, all those little steps coming down. Yeah, those used to have water on them.
I've never seen one. I think.
Now it's just, and you're not supposed to walk on them as steps, but when you drive by, it looks like these are the steps going up to the court. It's pretty impressive.
That's what I thought it was.
All right, that's the United States District Court. Now, in Florida, there are 3 United States District Courts. Predictably, the Southern District of Florida, the Middle District of Florida, the Northern District of Florida. But within each district, there's several courthouses. The Southern District of Florida's courthouse is in Miami. But there are also federal courthouses in Fort Lauderdale and in West Palm Beach with U.S. district judges that are theoretically Miami judges, but they only sit up here in Fort Lauderdale or in Palm Beach. But that's the Southern District of Florida of the United States District Court, the trial court for the federal court system.
Question for you.
Yes, sir.
Do you have to be a judge to get appointed to the federal court?
No. You have to have previously been a judge?
Yeah.
No, very often not.
So you
Very
said to be
often
an
not. Very
attorney?
often it's a political favor to a lawyer somewhere.
Right.
I think
but
you
just
gotta
had
be
to
a
an
lawyer.
attorney.
I
Yeah.
think. I don't know, maybe not. I don't know what the qualifications are. I think there would be a hell of a public outcry if somebody didn't have a little bit of legal experience or
Yeah.
a legal degree. But you definitely do not have to have ever been a judge before. Okay, and remember, the reason we're not gonna focus on these much, not much stuff happens in federal court. They're biggies, but there's not many cases.
So this only happens if we have a disagreement between states.
I'm sorry, if we only have what?
We only go to, say, the district court if we have a disagreement between two states.
Well, it's all the things we talked about earlier. Diversity jurisdiction, citizens in two states,
Mhm.
matters involving state statutes, federal statutes or federal constitution.
Okay.
And remember, we have an entire body of federal criminal law
Yeah.
with a United States attorney who prosecutes all of his cases in the U.S. District Court. Scott Rothstein case, that was in the U.S. District Court. Never quite figured out why. Probably because there was a bankruptcy case as a companion with it. And that, of course, is in the bankruptcy court. All of these Scott Rothstein defendants all got prosecuted in federal court, including his wife. And they all got sentenced by federal judges under federal statutes of RICO fraud.
Wasn't
These could all have been, forgive me, these could all have been Florida crimes, prosecuted in the Florida courts. But the federal court stepped in first. And it doesn't mean that Florida can't also prosecute you for the same crime, but they usually don't. Yes, sir.
wasn't like some of the investors, they were out of state? Would that
What,
make-
I'm sorry, investors?
Investors that he duped, Scott Rothstein?
Could be why. I mean, I just don't know why the United States District Attorney took precedence, the federal prosecutor, on these, but it could very well be why. It doesn't require that it be there, because you could just as easily prosecute somebody for fraud and embezzlement under Florida law if he stole money from a guy in California. He still did a crime in Florida, but that it could be why it ended up there. In any event, that's a lot of what you see in federal court. Bankruptcy for sure, federal district court, bankruptcy for sure, and violations of United States statutes. That means people not filing tax returns, all your IRS crimes, they're all there. Okay. Next step up the ladder in the federal system is called the United States Court of Appeal. That's the intermediate appellate court in the federal system. We are in, I think I may have mentioned this, or that we are in there are 12 of these courts in the country. We're in the 5th Circuit. Its court is in New Orleans, but it hears cases a few other places. It hears cases in Atlanta. I think it hears them somewhere in Florida occasionally too. This is the intermediate appellate court in the federal system. It is always a 3-judge panel, sometimes more. Nevertheless, very similar to Florida. And this means 3 federal judges issuing an opinion, deciding whether the federal district judge in the trial court correctly applied the law. That opinion is precedent. It's a holding. It's going to be followed. It's going to be followed by every district court in that circuit. And that circuit is 6, 7 southern states. And the federal district courts in Georgia and Alabama have to follow what this court in New Orleans says is the law for that circuit. And then, of course, there's the U.S. Supreme Court. Everybody knows this. 9 justices, simple majority, unlike Florida, 5 out of 4 wins. And boy, it happened all the damn time. So many of your Supreme Court opinions are 5 to 4. They're always writing opinions. Of course, they got staffs, they got clerk. And that obviously is very much the law of the land, and that is the law of the land in every court in the whole country. Not just the federal courts. State courts too. And that's pretty much it for the court system. Anybody have any questions? Yes, sir.
How do you, is there like a specific number of judges for the number of population? So like in Miami-Dade, because there's 3 million people here, we're supposed to have a judge for every 300,000 people, or?
You mean, how do they determine how many judges?
Yeah.
I'm sure there are formulas for that, but I don't know. It's not automatic by any means. In order for Dade County to get more judges, the legislature has to say so, because the legislature has to fund them. So Dade County judges will be up there saying, oh, yeah, we need more, we need help. We have more people, give us 5 more circuit judges. And the legislature not only has to approve, add 5 judges, but has to decide how to pay their salaries and their secretaries and their courthouses and their, I was going to say let's take a break for a second, but let me do one more quickie and we'll finish with chapter 1. And I'm going to say it's a quickie, but it's hugely important. And if we have time later this afternoon, I'm going to come back to this at length. But I'm taking longer than I anticipated, but the other chapters are going to be a lot shorter, I promise you. This is called ADR, Alternate Dispute Resolution. This is how do you get your case handled outside the courts. And this is huge. This is maybe 1 page in your textbook, but this is incredibly likely to impact what you're doing. What it really means is how to settle a dispute without the courts involved at all. And that's why it's called alternate dispute resolution. And it's really is just 2 things. It's mediation and arbitration. I'm going to tell you quickly what they are. And let's take a break. As I think I want to go a little more depth into this. Let's take a 5-minute break. Let's come back in and we'll still try to quit for lunch at 1. We'll try to quit for lunch at 1, but let's come back in 5 minutes. Quick restroom break for those who haven't, and because I do want to hit on this.
Oh, Frederick's not here because his wife had their baby.
I'm sorry. Did you say something?
No, okay. He had a little girl. But he says, don't worry, he'll be here for 7 o'clock. I can't afford to lose 27 that's when I'm being here. Alyssa says she's not here because it's a Jewish high holiday. So she'll be here next week.
Saw down before.
It is? Already?
Sundown last night.
Can I rewind this? He reminds me of Tracy. Yeah, he's slower though. But it reminds me. It's kind of dry.
Yeah, there's really no way to spice this up.
Wait, I can't say this stuff. I'm on Kelly.
That's Thursday.
I got a lot of respect for people that come learn.
Is that?
I have a lot of respect for people become lawyers. These are just
Oh, I know.
straight.
There was a point when I realized my eyes were wide open, but I completely drifted off.
We're just going through the book. Yeah, I do. I can read the book. That's it. But Tracy was heavy on that too. She just kind of did the book and
It's hard not to go off of the book. You know what I mean?
Okay. The book is well put together.
Yeah, I know it is. That's what I'm saying. You can't go all the way around it, really.
So overall, I think that means, you know, if you read the book and then come to class, when these tests come in, you should be pretty good. Because you get hit with it twice. If you took notes, you get hit with it 3 times. I'll pass on those notes.
Getting that WhatsApp right now.
Good job. Give the graduation just once you stand on it. It's great. But hopefully they do better this one.
Think Scott Rothstein's attorney wanted it to be in federal over just to get it out of Broward County?
Scott Rothstein's attorney doesn't get to decide who's prosecuting.
Oh, okay.
He's in whatever court he's been charged
Okay.
with the crime for, you know. And so the U.S. attorney stepped up and decided he would prosecute him. And I guess the philosophy was let all the cases follow there. These judges are familiar with it. I don't know whether there was any kind of agreement with the Broward County State's Attorney, Mike Satz, to say, okay, I'll keep hands off and you do it. It also, to a small extent, Scott's case was so political too, as we're all seeing on TV now. You know, it was connected with so many local politicians because he had funded them. And I think the federal judiciary is thought to be more independent. Maybe there was a perception that it'd be a good idea to do it in federal court and we won't have any local good old boy favors. And, could be. But every crime so far has been charged under federal statutes, but that does not mean they can't. I'm sure there's been an agreement that the state won't prosecute, but it doesn't mean they can't.
Oh, state.
Yeah, and this is not, you know, you hear about double jeopardy all the time. It ain't the same crime. You're charged with embezzlement under Florida law, it doesn't matter, you've already been convicted of a similar crime under federal law. That's not double jeopardy. Different crime, different statute.
How does the
Different
process?
prosecutor, different court.
How does that process work if you're going to be trial for a crime both in federal government and your local state government?
You can be if they're different crimes. If the courts decide they're sufficiently different, then you've committed 2 different crimes. That's not double jeopardy by any means.
And that's happened?
I'm sorry?
That's happened?
Oh, absolutely, it's happened. Yes, I can't think of an example for you right now, but sure. Sometimes both systems are all over wanting to prosecute this bad guy. Traditionally, you know, murder was a crime under state statutes and is prosecuted by the states. But it's also a major violation of somebody's civil rights to kill them.
Mm-hmm.
And that is a violation of federal law, and the feds can prosecute you for it, and that's the term that they use.
So can the feds?
Treason, or, you know, that is a crime identical under both statutes. Yes, sir.
So can the feds trial you for murder, and then your state trials you for like kidnapping if you did that in the same process?
Sure you can.
But if you cross state lines with the person you kidnap, it becomes a federal issue, right?
Both jurisdictions have kidnapping. There's a crime under federal law to kidnap somebody, and I'm not a criminal lawyer by any means, but that's one of the few I happen to know. Like the Lindbergh case, that was prosecuted in federal court. And, but kidnapping is one of the 6 capital crimes in Florida. Remarkably, kidnapping without killing somebody is a capital crime all by itself, even if you don't kill them.
So you might as well.
I'm sorry?
So you might as well get more bang for your buck.
Wait, everybody? We close? No, we're not quite. Okay.
More bang for your buck.
Valid question. It's a valid question. You might as well.
You can't say that in front of the
I'm not
priest.
planning on killing you. I'm just gonna shoot you with this thing.
She's been threatening me over here, Mark.
He's
Can you
making
step
Jamaican
in?
jokes all day.
Can you step in, Mark?
No, Mark will pray for you when I'm
Mediate
done.
this. I need some mediation, Mark.
Mark will pray for you when I'm done. I'm gonna make a big presentation like the danger presentation. For the Figure Challenge, I'm assuming I'm gonna make a big presentation.
You're not allowed to make our papers in landscape view, okay?
Listen, hey, listen. My thing worked.
We don't want landscape view, okay?
Can I tell you what happened though, like big and serious? What shaped that whole thing was the first picture that I got of the proposed project design. That's what ended up shaping, because I'm like, if I try to squish it, it's gonna look weird to fit on the, that just ended up turning, I was like, all right,
Well, you turn
Get
everything
it.
that way,
I feel good.
so. I'm surprised you write
Shut up. It's not
8.5 by 11.
How it functions.
Okay, folks, I got a lot of stuff I want to get through before we break for lunch in the next half hour. We're going to move fast.
That's the plus.
Alternate dispute resolution, ADR, mediation and arbitration. There are three ways that your matter can be handled by alternate dispute resolution. 3 ways you get there. One is if you sign a contract that says that that's how it's going to be handled. You can have a contract with anybody about anything that says if we get in a dispute, it's going to be handled by ADR. Or, if you're in a regular lawsuit, the judge can order you to go have arbitration or mediation. And thirdly, there are some statutes that say that any matter coming up under these statutes will be handled by arbitration. That's rare, but usually it's 2 parties agreeing a contract that if we get into a spat here, rather than go to court, we're going to use ADR, mediation or arbitration or both. Now, the reason is the public perception, and it's correct, it's faster, it's cheaper, and it's less emotionally draining than a trial. A trial will, a full-blown lawsuit will ruin your life with depositions and discovery and interrogatories and those things don't happen here. Here's what mediation and arbitration are. Mediation is a neutral third party tries to help you settle your case. Help you settle your case. That means we're going to put all the parties in a room together.
3 party, right?
And I'm sorry?
It's 3 parties, right? Is it a 3-party hearing?
Is it a third party?
Yeah, that's what I mean, 3rd party.
Well, I'm sorry. The arbitrator is a third party. He's a neutral third party. He's not any of the parties, and he's not their lawyer. A neutral third party is picked, and he's the mediator. And he's going to meet with the parties and their lawyers, and he's going to try to help them settle the case. Now, if we have time later, I'm going to go through how it all works and everything, but that's what it's all about. The mediator cannot dictate a settlement. He tries to talk both sides into settling and explain to them why it's better if they do, and explain to them the weaknesses in their cases. And you're probably going to lose. You better settle. And you're not going to win as much as you think you are. You better settle. And see if you get them to agree. And they start out in one room, and then they go to separate rooms, and then they send offers back and forth, and we'll go through that. But the point is, he tries to help them settle, and if they can settle, cool. The case, it's over. End of case. So you can imagine how the judge is like this. This is cool. This gets rid of a case. I don't have to handle it. Gets it off my docket. So the court's love. Arbitration is something else. That's the only other method of ADR. Arbitration, again, is a third party. Neutral. Third party. Not related to anybody. But he's going to decide the case. He's going to make a decision. Now, sometimes there's 3 arbitrators, sometimes there's 1. Usually it's a lawyer who's an expert in the area. If you're fighting over construction, let's have a construction lawyer. And he's going to make a decision. And usually it's binding. And that's called binding arbitration. Binding arbitration is we all agree that we're going to be bound by his decision. As a trial, no jury. You have witnesses, you have arguments, everything like a trial. And that guy's the judge for a day, or 2 days, or 10 days. But it's quicker, it's cheaper. You go do it right now. You may or may not have discovery, depositions and all this stuff, but you're definitely going to have testimony, and you're going to get a decision. Not necessarily right then, but you're going to quickly get a decision, and it's over, and the parties go on their separate ways. And if the arbitrator makes a ruling and says, you better do this, and you don't do it, the other side can then go to court and get the court to make you do it. So it's enforceable by a court if it was binding arbitration. If it was not binding arbitration, you go through all that stuff, and then everybody kind of gets a feel for here's what would happen if we went to trial, but not binding.
Specific performance, correct?
I'm
That's,
sorry. I can't hear you, I'm sorry.
That's specific performance that the court has to go to the individual and say to you?
Well, specific performance is a certain remedy that can be ordered by a judge. I'm not going to go into exactly what that is for everybody right now just because it takes too long, but the point is a judge can order you to have specific performance, or an arbitrator can decree specific performance too. And if you don't do it, then the parties can go get a judge to order you to do it. So that is a remedy. The point is, all of the remedies that would have been available to a judge are available to the arbitrator. He can make all the same rulings that a judge can. And a judge will back him up on it and force you to do it if you don't. But you get it done in a month or 2. And it's much less painful. Yes, sir.
Can you appeal an arbitration?
No.
No.
No. Unless you agreed in the contract that it would be appealable. Normally, it is not appealable. It's final ruling, it's over, period. Because you agreed to that going in. We're going to have binding arbitration, we're going to do what the arbitrator told us. Yes, sir.
Can you put that in any contract?
Anytime you want.
Like rentals?
If you want to.
Whatever.
You're going to see it more and more. And in fact, now I'm going to show it to you. I had wanted to spend more time on this, but we're going to do a quickie right now. And we will, as I said, we'll come back to it if we can later. Here is, if you will, be kind enough to get this moving around. Here's a residential sales contract form. This is an excerpt. And I'm going to show you how this comes into play. And I'm going to do this much more quickly than I anticipated, but I'm sorry, this chapter is just plain old taking longer than I thought it would. Everybody got one? All right. This is a standard form residential contract for sale and purchase. This This is put out by the Florida Association of Realtors. You look down at the bottom, 2013 Florida Association of Realtors, copyright on the lower right. That's whose contract this is. What that means is this is a standard form contract in use throughout the state by realtors. This one was given to me by my friends at Town Real Estate. That's their logo up at the top and the name down at the bottom, marker, One Town Real Estate, good friends. Realtors have these forms, lawyers don't use them. But because realtors fill out most sales contracts, you're going to see this on the sale of a house. And this is used statewide. Not by every realtor, but by most. What's going on here is this is a contract. You're going to fill in a name of a seller, a name of a buyer, and you're going to talk about the description of the house. And this is going to be the contract between the buyer and the seller, and we're going to do a deal. Skip down to the middle. There's one important thing I want to show you here. Obviously, you're going to fill in the purchase price. On line 24, you're going to see there's a deposit. Every real estate deal should have a deposit. And the important thing is, if you see just above there on line 20, the deposit is going to be held by the escrow agent. That's who holds the deposit. You know, buyer pays $10,000 to some third party, the escrow agent, to hold the money. Just go, I'm serious, I mean it, I'm going to do it. And so, the relevance of that is, if you go over now to the second page, all we're going to look at for this part of this is paragraph 16 on the second page, line 345. And this is a, sorry. Line 345, paragraph 16, dispute resolution, just like we talked about, alternate dispute resolution. All controversies, claims, or other matters in question arising out of this transaction or arising out of this contract or out of its breach will be settled as follows, period, colon. But period means this is what we are agreeing to do, and this is why you're not going to court. If you sign this contract and you have a flap, you're going to have alternate dispute resolution. And you can imagine why. Realtors would like it to be quick. Let's get on with the deal. Let's close it or have another deal. How are we going to make a commission here if we're tied up in courts for 3 years? So they want to move it. This is the realtor's form. So, section A here, line 348. That's why I brought up the escrow agent. Disputes concerning the entitlement to deposits. Deposits are held by that escrow agent. Buyers and sellers get in a fight over, buyer says, I want my deposit back. Seller says, hell no, I'm keeping it. That's a dispute over who gets the deposit. That's what this first section is. Disputes over entitlement to the deposits. End of the next line. Resolve the dispute through mediation. If that fails, then the escrow agent, the guy who's holding the money, is going to decide what happens next. Now, he can choose to go to court, but he can choose arbitration. The escrow agent has his choice of arbitration or the court, or God forbid, FREC, and that's a subject we're not going to get into at the moment. Now, subsection B on line 355, all other disputes. There are lots of other kind of disputes I could get into other than just fighting over the $10,000 deposit. Do I want to close or don't I? Was there fraud? Fights over, God, you name it, that are not fights over the deposit. Any other dispute, next line, parties will attempt to resolve the matter through arbitration. Failing which, the parties will resolve the dispute through neutral, binding arbitration. That means whatever the arbitrator says, it's it.
It's mediation first, then arbitration, right?
Mediation first. Mediation always first. I'm sorry. Mediation, you might skip mediation, but you would never have arbitration and then mediation. Arbitration, it's over. Mediation, you try to settle. If you can't settle, let's have this other guy decide at the arbitration. Now, the paragraph goes on at the bottom to describe what mediation is and what arbitration is and whose rules, this is a subsection C, whose rules we're going to use and who's going to pay the arbitrator and stuff like that. I'd like to go into some of those issues at greater length. We just don't have time now, I'm sorry, and I hope we get to come back to this because this is big. This is something you're going to deal with. You're going to be involved in mediation or arbitration someday if you're in the real estate business, and maybe often. Yes, sir.
Regarding the who pays for it, isn't it typically the one who's better off, so to speak?
These contracts all say you share the fees, you split the fee.
Share it?
Mediator's got a fee, you're gonna split it. Arbitrator's got a fee, you're gonna split it.
Okay.
All right. I don't like that, but that's what this contract says.
Okay.
You know,
'Cause I think
lawyers
sometimes
are much more into
employment,
something we call prevailing party.
they
If
pay.
you win, the loser should pay everybody.
Yeah.
Yeah, they don't do that.
But not in mediation, because nobody wins.
But not mediation, because you settle, exactly. Arbitration or litigation.
Right.
I'm a big believer in.
I did see that
loser
somewhere
pays.
though.
I'm sorry?
I want to say maybe it's like employment contracts that they do that, where the better off, the company overall will pay for the
You
arbitration.
could provide that. Anything you put in this contract is negotiable. I assure you, a lawyer reading this contract, if I'm reviewing this for my client, first thing I'm doing is I'm crossing out paragraph 16. Out, not doing it.
Yeah.
I believe in litigation, I believe in going to the courts.
Okay.
I just think, you get a better resolution, but it takes longer and it costs more.
Yeah.
Realtors want it done quick. Parties want it done quick as long as they win. If they didn't win, then we should have gone to court, you know? Well, that's too bad, you agreed to this. All right. I would love to come back to this, and I hope we get the opportunity to, but I'm going way too slow, and I need to get us out of this chapter. That's it. Those were the sources of the law, and how the courts are set up. And the only reason that we did this ADR here is because we did courts here. This ought to be a whole course. But because we talked about the court system, now we talk about what else can you do outside the court system if you have a dispute, and that's ADR. I'm going to do chapter 2 quickly before lunch, and then we'll break for lunch. Chapter 2 is easy. Anybody have a question before we move on? All right. Chapter 2, real and personal property. This should be a no-brainer. Real property is real estate. Real property is land. Real property is buildings. You know that. Basically, personal property is everything else. So we're going to talk about some examples. Now, what property really means is, I know it's this piece of land, bless you. But what it really means is the legal rights that you have that relate to that piece of land. The right to live there. The right to rent it out. The right to build a building. It's a thing, it's a piece of land, but it only means what you can do with it. Mostly economic, but not necessarily. But the legal rights that go with the ownership of a piece of land are what are important. And that's what we're dealing with here. Now, real property, as we talked about, is land and anything that is permanently affixed to it. That's a building. That's a dam. That's a whatever. Once you permanently construct improvements onto a piece of land, they become a part of that land and they are real estate altogether. That's all real property. Everything else is personal property. And sort of by definition, that means it's movable. Personal property is a car, a piece of paper. It's things that are not attached to land. Now we're going to get into in a minute, some things used to be personal property and then they become part of the land. But as long as they're still movable, they are still personal property. Two kinds of personal property. We're going to touch on this briefly because I'm major against the fact that this chapter goes off on personal property, because that's not what we're here for. But you've got to be at least exposed to this a little bit. There are two kinds of personal property. There's tangible personal property and there's intangible personal property. Tangible piece of property, pretty easy. Tangible means touchable. Can you touch it? Can you feel it? Well, it's tangible. But there are other things that are personal property that you can't so much feel. Bless you. A patent, copyright. Hell, a bank account. You may have the checks, but the bank account itself, it's personal property, it's not land. And it's intangible. You can debate some of these that are gray areas. The one importance of this, tangible and intangible, big importance in Florida, is that Florida has a tangible property tax with lots of exceptions, and until very recently had an intangible property tax. Now, the intangible property tax has been abolished, thank God. It was never a tax on bank accounts, but they used to tax accounts receivable and things like, yeah, file a return every year. It is my intangible property and here's my tax money. They finally abolished that. They still have a tangible property tax. Now, there are lots of exceptions. They don't tax your car, except when you buy your tag and all that stuff, but that's not an annual recurring tangible tax. But they tax furniture used in a commercial business. They tax your office furniture. If you have a motel, they tax all of the furniture in a motel. Every year you file a return. Most people don't do it because we now have an exception that all tangible property under $25,000 is exempt. So everybody says mine's under $25,000. But you know, artwork on the walls and everything, they used to come in and add up all that. Oh, you got all this artwork and we got this desk and furniture and all that. That's $100 grand. Your computers, that's $100 grand. And here's your tax for this year. And if you didn't self-report it, they come around and knock on your door and they want to see your stuff. And they still do that, but thank God they're running out of staff. We have to That's the only real importance between tangible and intangible, and it's not a big deal, but it is personal property and it is taxed. Now, I want to apologize on behalf of the author for one of the stupidest cases I've ever seen. This is the case that you read about manure piled on the side of the road. I just thought, my God, I cannot believe that they can't come up with something better than that. And is it tangible? Is it intangible? Has it become a fixture? Is it attached to the land? Is it not attached? Who cares? You know, that was really bad. But there is one more important concept in this chapter, and then we're done. And it's called fixtures. The fixtures are personal property, but they become attached to the land, and then they become real estate. So this is personal property attached to the land, annexed to the land, affixed to the land, they use all those buzzwords for it, then it becomes real estate. Best example for me is your central air conditioner. Quickie, hot water heater. You know, in Sears, personal property. Truck brings it out, it's still personal property. But they install it in the building and they attach it. They hook it up to plumbing, they hook it up to refrigerant hoses, screw it in, bolt it down, it becomes a part of the building. That's a fixture, and that's now real estate. Okay, that's huge important. I want to go back now to that sales contract we looked at for a minute. Go back to that with me for a minute. First page. Okay. We're talking about, remember we talked about there's a seller, there's a buyer, there's a description of the house, street address, city, legal description's a big issue we're going to get into later, tax ID number, all that stuff. Now, beginning on line 8, what's included with the house? Together with all existing improvements. Well, that's the building.
Fixtures.
And attached items including fixtures. Well, that's kind of redundant. An attached item is a fixture. Attached items including fixtures, I guess in any other attached item, but that makes it a fixture. Built-in furnishing. Well, if it's built in, it's attached. Major appliances. Interesting. They list a few. It's a good thing they list them. Refrigerator. Sometimes a housewife has a beautiful brand new $3,000 Samsung stainless steel refrigerator and she thinks she's taking it with her when she's leaving. Seller sells the house, put it on the moving truck, we're out of here. My refrigerator. Well, this contract says no. This contract says it's staying. We're trying to avoid disputes here, and that's why we're spelling these out, and I'm going to go into that with you at length, how these disputes arise. Dishwasher, washer, dryer. Same thing. Washer and dryer, sometimes they disappear before closing. Seller thinks it's fine, buyer thinks, hell, that's part of the house, I thought I was getting it. Ceiling fans, that's a biggie. You know, they're kind of screwed in, they're kind of attached. But they're sort of an electric appliance that you could sort of theoretically unplug and go. So we specify them here. Light fixtures, same thing. Now, attached wall-to-wall carpeting. Well, it's attached, yeah, therefore it's probably a fixture, right? But that's to differentiate from oriental rugs. Sometimes a gorgeous oriental rug goes wall-to-wall and you don't know whether it's attached or not. Well, these things create hassles, fights, disputes between buyer and seller. So let's spell it out. But the attached wall-to-wall carpeting, there's no question about it. When the seller leaves, he shouldn't be ripping up the damn carpeting. Draperies, drapery rods, window treatments, that gets a little funky. See stained glass, pieces of stained glass hanging in a window. Is that a window treatment? Yeah. Is it a part of the building? No. So they spell these things out. Now here's the good thing going on here. Two blanks say the only other items included are. If you ever get in one of these deals, list them. Put it. What else do you think about? What about a disposal? Kind of crazy for the seller to take it out. It's pretty attached, but it ain't listed here. It says all major appliances, but it spelled out appliances, but it didn't say which ones. Ice maker, trash compactor, microwave, big flaps over that. An attached microwave, like an arranged hood and everything, yeah, everybody says that's attached. Big old one sitting on the counter that just plugs in. Seller thinks it's like a toaster. That's going with me. Buyer comes for closing, where the hell's my microwave? You got to spell these things out. Next section, the following items are excluded from the purchase. Spell them out. If you're a seller, I think it's something important to me that I don't want the buyer to even get any faint idea that you're getting this. Put it down there. Pretty obvious you don't have to list my car. Of course you're taking your car. But what about a Tiffany stained glass hanging lamp that's an installed light fixture? Sure, I'm taking it with me. Not leaving that. Put it down there. It's great that these sections are here to tell the realtor, spell it out. Or whoever's filling out the contract, and you may be filling out one of these yourself. Broward County has a sales contract standard form produced by the Broward County Bar Association and the Greater Fort Lauderdale Board of Realtors. They work together on it, committee. Partly guilty for the length of it. It's 15 pages long. This one, 9 pages, which is bad enough. Our Broward County form's even longer. We have a third category. We have a section called leased items, and we make people fill in what's leased. Satellite dish, security alarm. Put them down there so that the buyer thinks he's buying your security alarm, and he gets there and finds out the damn thing belongs to Comcast. Cool, I thought I was buying that. You know, spell them out. So this is fixtures. Fixtures are things that are attached, and obviously are part of the real estate, but as you can see, there's going to be a lot of flap over that, and a lot of gray areas, and a lot of fights in this. Biggest flap I ever have in a residential deal. I don't do many residential deals, but you can't help it. Your friends, your family, your big clients buy houses. You know, you got to get stuck in them, and I do. I did. Was over a bar, and this was a monster. This was a $40,000 antique bar coming out from the wall. Huge backdrop to the bar with mirrors, drawers, racks for glasses and all that. Buyer thinks, hell, the buyer thought this room I'm buying is the bar. This house is cool, it has a bar. Seller's feeling is, I bought this at an antique store. It's not attached to the floor. The bar is just sitting there on the floor. This thing is just standing up here in front of a wall, just like a dresser. We go to the closing, they always have a walkthrough, the buyer walks through the house, comes into the closing screaming, man, who stole my friggin' bar? I'm not closing. Seller's in Virginia with the bar. Says, well, that's too bad, that's a piece of furniture, man. You're not bitching about the sofa. You're not bitching about the glass mirror on the other wall that I took with me. Why are you complaining about that glass mirror? That was a piece of furniture. And it was ugly. But it should have been spelled out. It's a perfect example, spell it out. If you spelled it out at the beginning, the buyer would have said, well, I'm taking 40 grand off the price. The seller would have said, okay, fine, you want the bar? It's another 40 grand, you know. But we'd have known, we wouldn't have had the fight, we wouldn't have had a dispute, the deal blew up. And then they fight over the deposit. So the buyer says, okay, fine, I'm not buying it, give me my deposit back. Seller says, hell no, I'm keeping your deposit. I didn't do anything wrong. You forfeit your 100 grand deposit. This was a big house on the islands off of Las Olas, as you can imagine, that would have a $40,000 bar. You know, and nobody bitched about the bar stools or anything, that's obviously furniture. But the buyer thought this was built in, there was carpeting around it, you know. Not wall-to-wall carpeting, because that would be a little bit of a giveaway if you carpeted around it and then there's a big hole in a concrete floor. There were nice oriental throw rugs around this thing, but it looked to the buyer like this was the deal. It's bad. And so the lesson here is spell it out. And you may be filling these out, and you will certainly be a party to some of these. Whoever you work for is buying and selling property. Now this doesn't happen as often if you're buying a shopping center or an office building. Buying a motel, it can happen. What's the inventory? What furniture's included and what's not? You know, the beds, the TVs, that's a big deal in a hotel. Okay. Want to make one more point and then we'll break for lunch, and by God, we'll do it right at 1 o'clock. There is one exception to the fixtures rule about it becomes part of the real estate. And it's called trade fixtures. Special kind of fixtures. A trade fixture is installed by a tenant. So it's only going to come up if the place is rented. A trade fixture is an item installed by a tenant used in the tenant's trade or business. I like the example of a barber chair. Barber rents some vacant space, gets barber chairs, bolts them down to the floor. Big old stud bolts coming through the floor to hold the barber chair from tipping over when he tips it back and everything. Boy, that's a fixture. That's an built-in, installed piece of equipment. It's not even furniture. Installed by a tenant for use in his trade or business. The big difference is this. When the tenant leaves, he gets to take it with him. And that's the whole difference here. The reason the law was structured in this area was to encourage tenants to spend money on their spaces. Do some stuff. Fix it up. If I had to leave all that stuff for the landlord, hell, I wouldn't do it. But if I get to take it with me, maybe I will. But it's bolted down, shelving, all kinds of stuff. It would be a fixture. It's a piece of personal property. It's attached to the real estate, so it's a fixture. But it's put in by a tenant as trade or business. And therefore, it can be separated from the real estate. It's no longer a part of the land or the building, and it can be removed by the tenant at the end of his lease. Assuming, of course, he did the full. You know, if he ends his term, moves out friendly, takes his stuff and goes, he's allowed to take that stuff. It doesn't become the landlord's. Obviously, if he doesn't pay his rent, the landlord's going to come in and claim, that's a fixture, that's mine. And, but that's a whole different issue. We'll talk about that when we talk about leases. That's it for chapter 2. Now, there's a lot more stuff I want to tell you about here that you are not responsible for, because I think it's incredibly stupid to be in this chapter. We're going to talk about, they talk about crops, and fructus industriales and naturales and all different kinds of crops, and are crops real estate or personal property? Yeah, you don't need to know this. Doesn't happen in Florida. Yeah, sure, we got farms, but it's just not an issue. It's not gonna come up. And then lastly, all this stuff at the end about secured transactions. That's all about personal property by definition. Secured transactions are how do you secure a loan when personal property is the collateral? Personal property. We're here to study real estate. I think it's nice that they put it in here to help you understand the distinction between the two, but it's not real estate. You're not responsible for any of that stuff. Anything else in the chapter after trade fixtures, don't pay attention to it. And that's it for chapter 2 as far as I'm concerned. Anybody have any questions? All right, let's go to lunch. Is there a clock in here?
Right by you.
Okay, thanks. 5 after? Is that right? Is that what it says?
Yes, sir.
All right. 1:35. Let's be back from lunch at 1:35 and we'll crank up again. Thank you. All right, thank you very much. Lunchtime reading. If y'all would, if you finish these student information forms, if you wouldn't mind dropping off, I'm going to go to lunch.
Go down there?
Yeah.
Yeah, I'll go with it.
Okay. How does everything is close by?
You want a sandwich from Presso?
Oh, you're very kind of brought something. Thanks a lot for offering. Hey, buddy. Tell me your name.
Robert,
Robert. Let me find Robert here.
I'm at the bottom of that list.
You Robert Saunders?
Yes.
Cool. Thank you, Robert. I appreciate all your input.
Wow, it's interesting stuff. I'll let you talk.
Well, that's kind of it. Thank you. I hope I can keep your interest at 4 o'clock in the afternoon.
That'll be the hard
That's the test,
one.
right? That's the litmus test.
Yes, that's when it gets tough.
Tough for all.
But it was done differently this semester. Last semester we did our long class first, and then we had our 2-hour class at the end. That was the hard one because we just went through a 6-hour class, and now it's like we've got a new instructor coming in trying to hold on to us.
And as I understand it, a lot of you all, did you have a class this morning from 8 to 10
Yeah,
with Fred? You did.
Yeah.
That's a long day too, man.
Yeah,
And
we're here 8 hours.
yeah, that's
8 hours. It's tough.
That's a long time.
Last semester we actually had one class that was 10 hours long. It was the only time we met with that instructor.
10 hours.
10 hours the whole day.
Straight one day.
Straight one day. Because you know the 2-hour class typically, like last semester we had a market analysis class, and we saw them every other week for 2 hours. So it was a 10-hour class.
Yeah. Okay.
So one of the classes we got it all done in one day, and that was tough.
Well, yeah,
To be in one class.
This is an endurance test. That's for
Yeah,
sure.
it is. But you know, many of us made the decision to come and do this. So you know, I'm pretty sure that everybody is pretty intuitive to what they're learning. They want to learn this stuff. So
Well, and as I understand the program, you don't have too much choice. It's
yeah,
not like electives. You got to take all these courses whether you like it or
Yeah,
not, whether
pretty
you
much.
like when it meets or not, right?
yeah. Where did I put that? Did I get that to you? Oh, there it is. But yeah, I think the law, from what I've learned so far, because also last term we had a land use regulation course, and my understanding of the law behind this is that it's very troublesome, you know, for a developer.
Well, I didn't know you, some people probably have not yet had that
They
course.
haven't.
And I know that's taught by a lawyer.
Yeah, Tracy,
Yeah, Schwarzenegger or something. Yeah, I don't know her personally, but I know she does a lot of work at the county level. And,
Yeah.
and I'm theoretically supposed to cover a little of that, but I ain't gonna do much of it, because I know they're getting it there.
Yeah.
I'm gonna dash down and eat something
That's
quick
fine, we'll
where
run
the
out.
sodas are.
All right.
All right, see you back later. Thank you, Robert.
No problem.